It is undeniable the importance of creative ideas and innovative technology in today's global economy. The Korean Intellectual Property Office, also known as KIPO, is the governmental agency of the Republic of Korea responsible for the administration and processing of patents, utility models, trademarks, industrial designs, and new intellectual property. Working at the forefront of the fourth industrial revolution, KIPO strives to realize innovation through supporting the adequate utilization of intellectual property. KIPO is affiliated with the Intellectual Property Trial and Appeal Board, which conducts trials on IP disputes, and the International Intellectual Property Training Institute, which provides training for IP experts and users. KIPO currently employs around 1,700 staff, including 843 patent examiners and 157 trademark and design examiners. Of these, 480 hold PhDs, 427 are patent attorneys, 28 are professional engineers, and 22 are attorneys at law. Over the past decades, the number of IP applications filed in Korea has increased to the extent that Korea is the world's fourth largest IP creator. KIPO has actively participated in international cooperative efforts in order to reduce examination workload and effectively enhance the global IP system. We closely collaborate with the IP offices of the United States, China, Europe, and Japan within the IP5. And through this successful framework, the TM5 and ID5 were created to improve examination efficiency and quality. To reduce the time and cost to acquire international patents, we are implementing the Patent Prosecution Highway with a total of 28 other countries. In addition, KIPO has been gradually strengthening examination cooperation, such as starting the Collaborative Search Program with the U.S. since 2015. KIPO provides prompt examination services. The average pendency of first office action at KIPO is about 10 months for patent and utility model applications, and about 5 months for trademark and design applications. KIPO boasts the advantages of world-class speediness. In order to provide high-quality examination services, KIPO carries out activities to strengthen examination quality control. KIPO provides 3 tracks of patent and utility model examination and 2 tracks of trademark and design examination so that customers can select an appropriate examination track according to their own IP strategy. The examination process at KIPO generally means going through the procedures of filing of an application: formality examination, request for examination, substantive examination, decision of grant, and registration. Applicants can file patent applications in Korean or English. KIPO has shortened the request for examination period from 5 years to 3 years in order for an earlier confirmation of rights. During the substantive examination stage, an examiner will ask an applicant to submit a written opinion and amendment if there are reasons for rejection. At this time, if the reason for rejection is resolved through the written opinion or amendment, the examiner will make a decision of grant, if not, a decision of rejection. If an applicant disagrees with the result of the examination, the applicant may file a request for an appeal of the examiner's decision of rejection. Subsequently, the Intellectual Property Trial and Appeal Board's decision can be appealed to the Patent Court, a high court specializing in IP, and an appeal against the Patent Court's decision can be made at the Supreme Court. IPR infringement cases can be appealed to the Patent Court from district courts. In patent examination, KIPO has introduced remedial measures to the grace period. Applicants can apply for a grace period before the official establishment of right or for a grace period at the point of filing. KIPO has introduced the Ex-Officio Re-Examination to prevent effective patents from being registered. In trademark examination, not only conventional marks made by symbols, Letters, colors, but also non-conventional marks, such as sounds and scents, can go through the registration process and be protected as trademarks. Validity of the reason for refusing registration of trademark is determined during the registration decision period rather than during application filing. In design examination, KIPO has extended the grace period from 6 months to 12 months. An affiliation of KIPO, the Intellectual Property Trial and Appeal Board, IPTAB in short, conducts special administrative judgment trials and appeals for resolving IP disputes of an examiner's decisions. One of the major cases highly requested is an appeal against an examiner's decision of rejection. The appeal proceeds in the order of formality examination, designation of an administrative judge, and examination on merit. If the request is accepted, it will remand to the examiner, and if the request is rejected, it can be appealed to the patent court. In addition, the IPTAB conducts various trials, such as trial for correction with opportunity to correct patent and utility models after they are registered. Invalidation trial, where an interested party may seek to retroactively invalidate the granted IP rights, and trial to confirm scope of IP right, for patent right holders, exclusive licensee, or interested parties can verify the scope of protection of a patented invention. The IPTAB operates a 3-track trial service in order to more efficiently handle trials that require expedited processing. In order to prevent defective patents, the IPTAB has introduced a patent opposition in which anyone can request on the grounds that there is no novelty, inventive step, and other reasons within 6 months from the date of the publication of registration. The IPTAB operates a trial fee refund service where the trial request fee can be refunded to the applicant if the examiner's decision of rejection is revoked without fault of the applicant. In addition, the IPTAB operates a video conference system which allows parties to remotely participate in an oral hearing at KIPO's Seoul branch office without physically being present at KIPO's Daejeon headquarters. Korea ranked 5th for the number of PCT applications, 3rd for the number of Hague applications. Korean, known as Hangul, became one of the official languages for PCT international publications, joining others like English, French, German, and Spanish. Based on high performance of PCT application, KIPO and 16 countries from around the world signed a PCT International Search and International Preliminary Examination Service Agreement to provide fast and high-quality service. As a result, numerous global companies continuously prefer KIPO as the designated office for PCT International Search Report. KIPO will continue to strengthen its performance of offering high-quality examination and trial services.